Hello, friends. Well, the politics of fear just doesn't want to take a rest. I'm sure by now you've heard about this memo that was issued by the United States Citizenship and Immigration Service on May 21st, 2026. This memo was called Adjustment of Status is a matter of discretion and administrative grace, and an extraordinary relief that permits applicants to dispense with the ordinary consular visa process. We'll talk about this memo. My name is George Pappas. I'm a former immigration judge, and now I'm practicing as an attorney at law based out of Asheville, North Carolina, and Boston, Massachusetts, serving clients nationwide. Ladies and gentlemen, this memo is a travesty. It's a memo designed to create fear, to make you think that you have to go back to your country to get a green card. It's telling you that if you're a bad person, you're not going to get your green card. What it doesn't tell you is if you have no negative equities, you don't need to focus so much on positive equities. I'm not going to go into the minutia of the memo, but what I'm going to tell you is that if you are eligible for adjustment of status, if you want to apply for a green card, do it. Find an experienced lawyer. Don't do it yourself. Don't. Yes, you may want to put some extra evidence about your good moral character, but this memo is designed to scare you. This memo is designed to scare you so much that you won't apply, or that you may actually self-deport. What the memo doesn't talk about is for that many folks who overstayed their visa, for example, even if you're married to a U.S. citizen. If you were to go back to your country, as this memo wants you to, if you overstayed for more than 1 year, you'll be locked out for 10 years. They don't tell you that. If the government really wants you to go back to your country and process your green card at the U.S. consulate, well, the least they could do is revoke that 1996 law called the Illegal Reform Act, IRA, which made staying in this country without authorization, or if you overstayed, unlawful. Unlawful in the sense that if you overstayed more than 1 year and you leave the United States, you're locked out. Those lockout provisions have kept people in the United States. Before that law, you could go back and forth without those penalties. So this memo wants you to go back, but they're not telling you if you do. For many of you, you'll be locked out for 10 years. Talk about a nice way to separate families from each other. Talk about a nice way to create fear and play on people's ignorance and put them into a trap. The trap is, oh my goodness, I've got to do consular processing. Darling, let me go back to my country and we'll finish the process there. Of course, some of them will. As soon as they get on that plane and leave, they're locked out for 10 years, and good luck trying to get back before 10 years. So that's why this memo is dangerous. It's a propaganda ploy. It was written by someone who doesn't know the law. And last but not least, this memo is not the law. In this country, in the United States, what is the law? Number one, Constitution. That's the fundamental law. Number two, statutes, legislation passed by Congress. That's your second level of law. What's three? Agency, government regulations. Those are the three pillars of law in this country. Memos are not the law. Just remember that. Don't let this memo scare you. I talked about how it could be solved. If we get rid of the 3 to 10 year bars, which penalize people who've been here without permission for a certain period of time, and if they leave, penalizing them for 3 or 10 years, that's what's preventing millions of people today from processing their green card applications in the United States. They're still in the shadows because of this bar. So, continue to file for your adjustment of status. Make sure you work with an experienced immigration lawyer. Don't just find any lawyer in the yellow pages. That's not going to work. These are hostile environments. Do it yourself is no longer viable in this environment. They are waiting for you to make a mistake. Don't fall into that trap. But don't give up pursuing your rights. You have the right. If you were inspected at the border, if you had a visa when you first came in, you have a right. If you have a U.S. relative, an adult son or daughter, or your spouse, U.S. spouse or legal permanent spouse, to apply for a green card. Everybody talks about, we want legal residence. Well, make it easier for people to be legal. The issue of discretion has always been there. This issue about extraordinary discretion, that's there to scare the officers. Now they're being intimidated. They have to look over their shoulder and say, my God, do I have enough evidence of extraordinary ability to pass this? You know, so now they are being second guessed, even though they haven't made a decision about what to do yet. They're being told right now in certain parts of the country, don't approve a 485 adjustment of status. Let your supervisor review the whole account. We don't care about your recommendations. Don't tell the clients or the applicants that they're going to be approved, because you can't do that. Now, to be fair, in the old days, before this memo, if an officer felt inclined that you would be approved, they would say, we're going to recommend approval, and 9 times out of 10, the supervisor would sign off. Now they can't even say that. They can't say, I'm inclined to grant, because they don't know what they're supposed to do. So again, don't hesitate to apply if you qualify. Make sure you work with an experienced lawyer. But the politics of cruelty has many tentacles in this environment. This memo is just part and parcel. Immigration judges, immigration courts, they no longer have due process. Judges have a financial interest in immigration courts to make sure that they rule within a certain confine, despite their so-called discretion to promote fair hearings and due process. Otherwise, as Todd Blanche said just a few days ago, they will be fired if they don't speed up their, what they call their docket, and remove cases. Well, I'm filing motions to terminate in front of these judges because these courts are no longer fair. I'll go into that issue later on, but I am fighting back. I'm calling it what it is. It's an unfair court system. It's being interfered with by the White House, by the Executive Office of Immigration Review, and the Department of Justice. Attorneys, if you're listening to this video, you got to fight back. You got to fight those motions. You got to file those motions to terminate at the master hearing. Don't wait for the individual. Hit them hard. Preserve your appeal with the circuit courts, because you know BIA is not going to help you. That's another rubber stamp that's been hijacked. Your only due process opportunity for a fair hearing may have to rely on what the circuit courts rule. Preserve the objection so you can appeal at the circuit court level. So, ladies and gentlemen, last but not least, one final reminder. This memo from May 21st is a scare tactic. It's there to intimidate you. Don't fall for it. If you qualify for adjustment of status, file. If you have an application pending, talk to your lawyer. You may want to file some more positive equities, things that you've done well, good moral character letters. You still have time to supplement your file, but don't stop. Don't give up. We'll talk more about this. Have a great day, ladies and gentlemen. Thank you.